You're listening to continuing coverage in the suitcase murder, the trial of Sarah Boone, from the Hidden Killers podcast and True Crime Today. Now, back to the courtroom.
Madam Clerk, I'm ready.
Case number 2020 CF 603, the state of Florida versus Sarah Boone, appearances of record state.
Dave Ketchtor on behalf of the state.
William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right, Ms. Boone is seated at counsel's table wearing a light gray suit and a white blouse. She is in custody, however, will not be wearing any restraints. As such, we will continue to stand when our jury enters and exits. We're here for a charging conference. The court has reviewed, I believe, both parties' red lines as to the jury instructions, including, I believe, that was submitted last night, the defense's red line as to the jury instructions that were provided by the court. Let's try to get as much done as we can until our jury arrives. I believe what we had discussed yesterday was starting at the beginning and moving through as quickly as possible until we get to the real meat of some of the issues in the 3.6F and the 3.6G instructions. Mr. J?
May I remain seated during the charge conference?
Yes, sir, you may. Thank you. All right. I have in my hand a 34-page document that was emailed to the court last night by counsel for the defense at 12:06 a.m. from Lauren Henderson. That's what the court's going to be relying on. Does everyone have that in front of them?
Yes, sir.
Defense.
Paces, yes, Judge, I do.
Okay, all right, let's start on page 1 of 34. 3.1, Introduction to Final Instructions. Any objection to the form of this instruction? State.
Now I'm confused. I don't know that I have a 34-page document from them last night. There was an attachment. There was an email at 12:06.
Hang on, let me make sure.
Attachments. 36F, separate red lines. 36G, separate red lines. 8.9, culpable negligence, red line separates.
Give me a moment. Then it was what was sent at 11:31 yesterday.
That 34-page document I have.
Okay.
Oh, 31. I don't know if it's 34. It says 31 to me.
I have it as 34. Okay.
Excuse me, Judge.
Yes, sir.
Can I have Ms. Henderson explain how she sent the document?
Fine by me.
Your Honor, yesterday morning, 11:30, I sent the red line instructions from the defense based off the document you had sent to us yesterday morning. And then last night, we approached and I had asked if that format was okay for you. And I believe Mr. J had said, could the defense send separate 3.6, 3.F, so it'd be easy to incorporate in your final instruction.
And that's what was sent at 12:05 last night.
Sir.
All right.
Just for more convenience for you.
Understood. Okay.
Thank you.
But the balance of the instructions, because that just addresses those.
I'm sorry, what was that?
What you just advised only speaks to the 3.6, 3.6G instructions.
And F and culpable negligence.
Correct.
Yes, sir.
Okay, all right. So I'm talking about the balance of the instructions that may or may not be at issue.
Yes, sir. That was the balance of instructions that are not at issue. Those are what was sent in 11:30.
Okay, all right.
My confusion is the court is indicating they have a 34-page document.
Yes, sir.
I have a 31-page document that was emailed to us by Ms. Henderson at 11:32 in the morning.
Are you looking at October 24 at 11:31 a.m.? Subject, defense proposed jury instructions in red line format?
I'm sorry, Mr.
No worries. I'm looking at the email correspondence of October 24, 2024, 11:31 a.m. Subject, defense proposed jury instructions in red line format. Is it possible that you don't have your track changes are off, and maybe that's why? That's the difference?
Where the track changes, please?
In Word, under review, or I can just have Madam Clerk print out 2 more copies. And we could just work our way through that.
Quick track changes for everyone is still only 31 pages.
Okay. I just forwarded to Madam Clerk. I'm gonna have her print out 2 copies. That way we've got hard copies, so we seem to be all on the same page. Both parties have them? All right, both parties have what was provided to the court yesterday, a 34-page document, which includes the defense's red line with regard to the proposed jury instructions. We'll start on page 1 of 34. Instruction 3.1, Introduction to Final Instructions. Any objection to the form of this instruction, State?
No, Your Honor.
Defense?
No, Your Honor.
Moving to page 2 of 34, Instruction 3.2, Statement of the Charge. State?
No objection.
Defense?
No objection.
Moving to page 3 of 34, 7.1, Introduction to Homicide. Those 3 paragraphs, any objection?
No objection from the state.
No objection.
Moving to the next portion, Justifiable Homicide in the singular paragraph. Any objection, State?
No objection.
Defense?
No objection.
Moving to Excusable Homicide and the 4 paragraphs, including paragraphs numbered 1, 2, and 3. State?
No objection. I have no objection to anything I submitted to the court.
Okay, thank you. Defense?
No objection.
Moving to page 434, 7.4, second-degree murder instruction. Defense, any objection to the form of the instruction?
No objection.
And also the removal of the lesser-included chart on page 5 of 34, correct?
Correct.
Moving to page 6 of 34, instruction 3.4, when there are lesser-included crimes or attempts. My only question is, if I understand from the defense, they're looking to see culpable negligence is a lesser included?
Yes, Your Honor.
Would that not need to be included here?
Yes, Your Honor.
Okay, so is the only addition to this, the balance of the 3.4 instruction would be correct with the exception of the last sentence, which would read, the lesser crimes, plural, indicated in the definition of second-degree murder is manslaughter and followed by culpable negligence.
Yes, so it should go to R. Yes.
State?
State objects. There's no evidence to support a misdemeanor culpable negligence lesser included offense for a category 2 lesser to be included in the jury instructions. They both must be supported by the charging instrument as well as the evidence in the case. There is no evidence in this case that he only suffered culpable negligence. The crime for culpable negligence with death is manslaughter. Culpable negligence isn't even a category 1 lesser of manslaughter. It's a category 2 lesser, which includes, by inference, there must be some evidence that her culpable negligence did not result in death.
What's your response to that?
Judge, the instruction that we're asking for is 8.9. It reads to prove the crime of culpable negligence. The state must prove the following 2 elements beyond a reasonable doubt. 1, Sarah Boone exposed Jorge Torres Jr. to personal injury. And 2, she did so through culpable negligence. As to the fact that there is evidence of culpable negligence as to the case in the fact that Ms. Boone, while Mr. Torres is still in the suitcase, goes upstairs. As to it being charged, it's a category 2 lesser included that's available to the defense. Defense can get category 2 lesser included offenses as long as there's evidence to support the category 2. And there is evidence in this case to support the category 2 lesser included. That's why we're asking.
Any other further argument, Mr. J?
No, Your Honor. Thank you.
Okay, all right. At this point in time, the court is inclined to include the culpable negligence as a lesser included. We'll get to the instruction momentarily. Any other revisions to the 3.4 instruction, defense?
No, Your Honor.
Moving now to 7.7 manslaughter, there are some objections. The defense is now objecting to paragraph 2C, the death of Jorge Torres was caused by the culpable negligence of Sarah Boone. So how could you ask for a culpable negligence instruction and then object to 2C in the manslaughter instruction? Logically having trouble understanding that.
This is my argument, because I'm not arguing that there isn't evidence of it, because I just said there's evidence of culpable negligence. The difference is, and I think the burden is different from the state, because it's not alleged in their information.
Does not the instruction say give 2A, 2B, and or 2C depending upon allegations and proof?
Yes, the allegations would be the information.
Okay. Any response, Mr. J?
Judge, it's a category 1 lesser. All the theories are included in that. The language does not need to be included in the charging instrument. And quite frankly, it's not inconsistent with the language in the charging instrument. She's accused of having a depraved mind when killing him, and what the evidence has also shown is that she was heavily intoxicated when she made this decision. That supports a conclusion for a trier of fact to reach that this was out of culpable negligence, and if they reject our argument that it was done knowingly and out of hatred, ill will, spite, etc.
Any other argument, sir?
No other argument.
At this point in time, the court is going to overrule the defense's objection as to the objection to 2C in the manslaughter instruction, including the final 2 paragraphs of what the definition of culpable negligence is on the bottom of page 7 of 34. It seems like it's stipulated between the parties that 2B, Sarah Boone intentionally procured an act that caused the death of Jorge Boone, should be Jorge Torres, is not applicable. Is that correct, State? Is that correct, defense? Okay, thank you. And also, since 2B is not applicable, the to procure definition will not be provided. Any other questions regarding the 7.7 instruction?
No, sir.
No, Your Honor.
No objection to what they suggest is the definition of culpable negligence as the court's indicated.
With regard to the
Second lesser?
the second lesser? Yeah, thank you.
No objection to that proposed instruction.
All right, very good. Thank you very much. What is the instruction number for the culpable negligence instruction? I think it's 8.9, isn't it?
8.9.
Okay, thank you very much. Moving now to page 10 of 34, 3.6D, voluntary intoxication. Does this now need to address culpable negligence? Or is that only...
No, yeah, we would request to add it, the culpable negligence, since it's going to be given, so it should read second-degree murder, comma, manslaughter, comma, or culpable negligence.
You're talking in the last sentence, correct? Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence,
Yes,
correct?
Your Honor.
Thank you. Any objection, defense?
No, I agree, Judge.
Thank you. Do we want to take an attempt to address the 3.6F?
I would suggest we do that later and see if we can just get not
This-
3.6 done.
At this time, just going to make a note that we're going to bypass the 3.6F instruction and 3.6G instruction. That'll take us all the way to page 23 of 34. Instruction 3.7, plea of not guilty, reasonable doubt, and burden of proof. Any objection to the form of this instruction, defense?
No objection.
Moving now to page 24 of 34. Weighing the evidence, 3.9 instruction.
Should we go to 3.7, plead not guilty?
Did I skip it?
Yes, sir, page 23 of 34.
I'm sorry, I thought that's what we just covered, Mr. J. I apologize.
Oh, I was just making sure that there were no edits that either the court made or the defense made, so I was scrolling, but no objection to 3.7.
Okay, thank you. Moving now to page 24 of 34, 3.9, weighing the evidence. Looks like give as applicable paragraphs 6, 7, 9, and 10 have been struck. Is that acceptable? State.
Yes, Your Honor, I agree that 8, the inconsistent statement instruction, should get bumped up to 6.
Agreed.
And the remainder should not be read.
With those revisions, is that instruction 3.9 acceptable to the defense?
Yes, Your Honor.
Okay. Moving now to page 25 of 34, the latter portion of the 3.9 instruction. Any objection to the language contained on this page? State.
No, sir.
Defense?
No, Your Honor.
Moving now, the 3.9A instruction was struck by virtue of Ms. Boone testifying in this matter, so that need not be addressed. The 3.9B defendant's statement instruction also included the requested language by the state. Is there any objection to the form of this instruction at this time? Defense?
No, Your Honor.
Okay, Ms. Boone, earlier this week, and I can't recall if it was yesterday or the day before, the state had filed a motion seeking to add additional language to this instruction. And I had read that language to you at that time. Do you want me to read it again to you this morning?
Yes, please.
Okay, so I'm going to read you the entire 3.9B instruction. 3.9B defendant's statements reads, a statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get him to make it. That should be revised to the feminine. Any objection?
No, Your Honor.
Defense?
No, Your Honor.
That is the form instruction created by the Florida Supreme Court, ma'am. What has been added is the next paragraph, which reads, law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Similar to other conversations we've had this past week, ma'am, I don't want to know about specifics of any conversations that you had with you and your attorneys, just simply whether or not those conversations have been had. Did you and your lawyers discuss the proposed language that I just read to you?
Yes.
Do you have any questions with regard to that proposed language?
No.
Are you in agreement with this additional language being added to this defense?
Yes.
All right, thank you, or to this instruction rather. Thank you. The last sentence read, if you conclude the defendant's out-of-court statement, was not freely and voluntarily made, you should disregard it. Any other clarifications to that instruction state?
No, Your Honor, thank you.
Defense?
Judge, in looking at it, it says in the final part, consider whether the defendant's statements, can we replace and put rather Sarah Boone's statements?
Where are we specifically, sir?
In the state special that I have no objection to, it says, this is, however, one of the factors you may consider whether the defendant's statements, if we could have Sarah Boone's statements, were voluntarily made.
The language used all throughout the instruction is the defendant.
Yeah, I tend to agree with the state on that.
Okay.
Rule 3.10, or I'm sorry, instruction 3.10, rules for deliberation, page 28 of 34. Looks like the parties agree that paragraph 7 is not applicable.
Yes, sir.
I agree.
All right, that would change paragraph 8 to 7. Any other revisions to 3.10? Defense?
None from the defense.
Moving to 3.11, cautionary instruction. Defense?
No objection.
The court then interlineated on page 30 the 2.7 closing argument form instruction. Any objection to that instruction? State.
No, Your Honor.
Defense?
No, Your Honor.
Moving now to 3.12 verdict instruction, page 31 of 34. State.
No objection.
Defense?
No objection.
Moving now to 32 of 34, instruction 3.13, submitting case to jury. The only other question I have for the parties is with regard to, I believe it was Exhibit A, the suitcase. Are we going to send that back, or is that going to be viewable upon writing similar to the baseball bat?
No reason that it can't be sent back.
Okay, agreed?
Agreed.
Okay, all right. Is this instruction acceptable to the state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Very good. And then moving to, that concludes the, except for the 3.6F and 3.6G instruction, that includes the verdict, or the instructions. I'll have Anita clean that up and send it to the parties so that we have a cleaner red line to work with. The only other question that I think we can address this morning is the verdict form. I received the defense's verdict form, and it looks like manslaughter is no longer being sought in the verdict form. Manslaughter was struck out, and it was just culpable negligence.
Under the defense's part, yes.
Right.
Yes,
Okay.
Your Honor.
So how do we want to address the verdict form then? Because if we're giving instructions on manslaughter, it certainly needs to be included in the verdict form.
I understand, Judge, but the defense isn't requesting manslaughter, but if it's instructed, it has to be in the verdict.
Okay. So the verdict form would read, we, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. Is that acceptable to the state?
Yes, Your Honor.
Is that acceptable to the defense?
Yes, Your
All right. Similarly, I'll have Ms. Barrios make those revisions and submit them to the parties as soon as possible. Anything else, state, we need to address before? Bruce, do we have everybody as of this time? Everybody's here? Thank you, sir. Other than the 3.6 instructions and the state's request for other instructions, which I think we'll have to table for now.
Yes, sir.
Are we prepared to go ahead and bring in our jury at this time?
Only thing I wanted to bring to the court and the defendant's attention was apparently yesterday at lunch there was some sort of domestic violence event out in the quad. A coworker indicated that without believing it was any particular jurors in this case, that he did see people with juror badges in and about the area. So I don't know if that warrants inquiry by anybody.
Defense?
I think it should be mentioned.
I agree.
Okay.
I agree.
Just to see,
Sure.
we spent all this time, we've got a bunch of alternates. Let's utilize them, but I do have an issue.
Yes. What do we got?
I think the state attorney, the last piece of evidence is they've extracted from Sarah Boone's phone a bunch of pages of text messages. And I believe their intent is to introduce all those text messages, which are quite a few, but I think they want to read specifically out a few to the jury. My only concern is I don't know which ones they're going to read out, and under the rule of completeness, if there's a thread where it needs to be put in context, we would ask that all of that be read. So I don't know exactly what they're planning.
Mr. J, any response?
It's going back with them, just like I told them during some of the body-worn cameras. Only some of it's published, it's all going to be there for them to use. I do not intend on reading all 108 pages. I don't intend on trying to delineate what contextually is one conversation from the other. I think it's just fair to say this is all going back with you. You're going to have a scrub laptop. You're going to be able to view it all.
Okay. Mr. Owens, you can make any objections you deem necessary at the time, and we'll address it. Because it's just hard for me to say, what should or should not be. I understand the state's position, but if it's something that's you believe in the rule of completeness should be provided at that time, regardless of it going back, we'll address it.
It's going to be about 40 minutes worth of reading text messages. Are we going to have some people come in to read the messages?
Again, I'm not sure how long it's going to take. I did not practice reading what I'm going to be reading in the mirror. Number two, no, I don't understand why a witness would be called. It's in evidence. The lawyers can now publish them.
Anything further, Mr. Owens? Okay, all right.
Not on that issue. I would like to take like 5 minutes to use the bathroom.
Sure, we can do that. Okay, so I don't want to highlight that it was a domestic violence event. So are the parties, is it acceptable to the parties to inquire of if anyone heard or participated, got any information, or observed anything of the event that transpired yesterday afternoon in the courtyard? Is that acceptable?
Yeah, you definitely shouldn't suggest what it was.
Agreed. Okay, got a thumbs up from Mr. Owens. All right, we'll take a 10-minute recess. We'll just plan on bringing back here at 9:30. We'll bring the jury in at that time. Thank you all very much. You all can be seated. Thank you. All right, we're back on the record, case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for counsel, starting with counsel for the state.
Steve Castro on behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone is still seated at counsel's table. Are we ready to go ahead and bring in our jury at this time? State.
Yes, sir.
Defense.
Yes, sir.
All right, let's stand and bring in our jury.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, members of the jury, you can be seated. Members of the jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Just again, if you could raise those hands, confirm you comply to the court's instructions. All right, all hands have been raised. Thank you very much. Members of the jury, before the state continues with their evidence presentation today, I just have a couple of questions to go over with you. Yesterday, there was an event in the courtyard of the Orange County Courthouse. Did anyone happen to observe that event? If you did, please raise your hands at this time.
What do you mean by observed?
We'll get to it.
Okay.
Okay. Did anyone happen to hear anything during that event? All right, and record reflects no hands have been raised. Did anyone see anything during that event? All right, juror number 2, first row. Thank you, ma'am. Did anyone participate in that event? Record reflect no hands have been raised. Did anyone receive any writings or review any material from that event? Record reflect no one has raised their hands. Can the parties approach for a moment? All right, members of the jury, I'm going to send everyone out except for juror number 2 in the first row. We've got a couple follow-up questions for you individually, ma'am. Same instruction I've given you all previously. Please don't conduct any independent investigation or research as to the person, places, things, or charge involved, and don't have any discussions amongst yourselves or anyone else, and we'll bring you back in as promptly as possible. Thank you. You all may be seated. Thank you. Juror in seat 2 on the first row from right to left. You had advised, based on the court's question, that you had observed something, and you said, what does observed means? And instead of getting that out in front of every other juror, we just want to have that individual conversation with you now. So tell me what it is that you saw or heard or anything yesterday in the courtyard yesterday.
When we were walking back from lunch, and we saw that they were gathered, and I asked the deputy if he knew what was going on, and he said it was somebody Bain talking about domestic violence.
Okay. And you said we were walking. Who's we?
Another juror. I don't want to say her name.
Okay. All right. Is that a juror that was on our panel here?
Yes.
Okay. All right. Do you recall where they may have been seated?
No. In the back, over there.
Okay. All right. Do you recall what color her hair was?
Yes.
What?
Would you like me to tell you?
Please.
Dark brown or black?
Is it the shorter juror? Okay. Thank you very much. State, any further questions?
And after you were told what was going on, then what happened?
I walked back in.
All right. Did you hear any of the speakers?
I couldn't hear anything. No.
Anything further from the defense?
Ma'am, did that affect your ability to be fair and impartial? Thank you.
Can the parties approach for a moment? We appreciate you, ma'am. Thank you so much. We're going to go ahead and bring in the balance of the panel. You can just hang out where you're at, okay? We stand for you. You do not need to stand. We stand for you.
Jury entering.
State, you recognize our jury.
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, y'all can be seated. Thank you. Again, members of the jury, if I could see those hands, you complied with the instructions during that really short break. Record reflect all hands have been raised. Thank you very much. Mr. J, you may proceed, sir.
Permission to publish from States 21, which was previously marked as P for identification.
You may proceed, sir.
Again, this is a DVD exhibit with 2 folders in the main directory. One entry is in a folder called Attachments. Another is a PDF labeled Extraction. And for the record, it is 108 pages, and the entire document will go back to the jury, and there will be a laptop provided to them to utilize this exhibit. For purposes of publication, I'm going to go by page number and date unless something requires more specificity. And for to and from, I'm going to just use the name of the contact if one exists or the phone number if one doesn't. On page 1, creation time for notes, 7:49, asking Jorge or George not to be despicable to me, making more drink after he guzzled his and I shared mine. on page 2, date March 8th, 2018. You are now in a relationship with Jorge or George on Facebook. Metadata entry 100014, etc. for Jorge Torres to Sarah Boone, owner. Page 3, May 21st, 2019, from 407-716-8684 to Melissa. And he can still live here, correct? Or until I decide to finally get him out if he doesn't clean up his act after tomorrow? On page 9, May 30th, 2019, from a contact labeled as Mom, Jorge or George, to 407-716-8684, which I will just refer to as owner in future references. Where is my clippers in the gray box? From owner to Mom, Jorge, all capitals, dumpster, separate message, like you, separate message, so is your 2 shirts, separate message, no more Rick and Morty, a response from contact Mom Jorge to owner, okay. From owner to Mom Jorge, Lucas cried when he saw the adventure fund was gone, thank you, no wonder you're out, fuck off. From owner, he's the one that broke it because you took it. From owner, wanted to go on an adventure. On to page 10. From owner, be proud, feel good. You made my, quote unquote, our son cry. Cheese stick, Lucas, your kids, get the fuck out of my life and my son's. No one, spinster, good, for nothing, dumpster diver, that's what you are, and the rest of you. Later on this same page, owner to Mom Jorge, get all of you, mean, selfish, fuck all you, your firstborn is a joke. Going on to page 11, same date of May 30th, 2019, from owner to Mom Jorge, get the fuck out of my life. Lucas 2, bad influence. From Jorge to owner, I am, as you can see, go drink your life away. From owner to Mom Jorge, your kids are too. Yuck. Shucks, I only have one. Beaters, your 3 together. Yuck. Going on to page 12, from owner to Mom Jorge, still dated 5/30/2019. Gross, and all the time, gross. Mom Jorge to owner, I love that guy, I love that guy. You're the one who kicked me out. Owner to Jorge, Mom, finally. Get your shot together and check me out in 2 to 3 months. Hope you're there. Unless I find someone better. Shit. Together. From Mom Jorge to owner, are you serious? Are you serious? Owner to Mom Jorge, that's what happens? No. Mom Jorge to owner, I'm helping out Dad right now. Call you in a few. Owner to Mom Jorge, can you help me put out, fuck off? Jorge, Mom to owner, How? No problem. From 267-216-5170 to owner. Damn, you can only talk when you're drunk and talking shit. Owner to the previously mentioned 267 number. Stop calling, texting my phone. He's not here anymore. And it's damn. 267 number to owner. NP, you didn't have to be a bitch about it. Owner to 267. Going on to page 13. Still May 30th, 2019. Yo, I like you all. He's a dick and the sheriff just left. Sorry I couldn't text back. I'll always respect you all. You know that. He's not here anymore. And yes, I am a bitch. So are you. 267 to owner. Look, I'm not here to be taking shots at you. I never called you a bitch. I said you were acting like one. I'm not going to be here going back and forth on some childish shit. Have a good night. Owner to the 267 number. Friends forever, thank you. Would love to chat sometime. Call his parents, I guess. Further down on page 13, now on to May 31st, 2019, from owner to mom Jorge. Tell Jorge to call me. I want my things he took. I have his birth certificate and propane certificate. Until then, if he wants those back. And I have your quote-unquote art box. Mom Jorge to owner, stop being petty. I did not take anything that wasn't mine, I swear. Owner to Mom Jorge, you're a liar. I never can believe you from all the other lies. You stop being petty and take shit like you always do. Another one bites the dust, Jorge. Hope you're miserable like you've made everyone else. Mom Jorge to owner, I'm not lying. Owner to Mom Jorge, Lucas said he won't miss you either. When I get mine back, you'll get yours. Mom Jorge to owner, I didn't take it. I'm coming over in a few to get my stuff, and I'm coming with Jean and Melissa. Going on to page 14. Owner to Mom Jorge, go for it. Bring mine W. Mom Jorge to owner, I don't have anything of yours, that's why I'm coming with them so they can vary that. Owner to Mom Jorge, I don't care. They're not going to babysit you because you're an asshole and got kicked out after being taken off the lease. Mom Jorge to owner, they seen what I had in my hands. Owner to Mom Jorge, still don't care or believe you. I'm going to get Lucas anyway, so don't waste their time or mine. Mom Jorge to owner, exactly. Owner to Mom Jorge, you were a visitor and a terrible resident, boyfriend too. Just go away unless you bring my stuff. Mom Jorge to owner, I don't have your shit, Sarah. I need my birth certificate. Owner to Mom Jorge, I don't give a shit either. I worked for that birth certificate, voter's registration, and your ID card. Just because your name is on them doesn't make them yours. Even paid for them. I needed you to be a man and take care of me, not beat me, call me names, and make me feel like I'm not a person. Not giving back until I have mine. Mom Jorge to owner, whatever, Sarah. Owner to Mom Jorge, next step is restraining order. Know that. You can come over here 100 times. Doesn't mean I have to open the door. Good one, Jorge. Go away. Mom Jorge to owner, whatever. Owner to Mom Jorge, it's been a great day without you. Will be from now on. Mom Jorge to owner, you need to do. Owner to Mom Jorge, enjoy living with your parents at 41 with no girlfriend and lonely. It was the inevitable, just like it has been before. Owner to Jorge, Mom, did you take Lucas's sunglasses? Mom Jorge to owner, OMFG, no I did not. Turning to June 2nd, page 15. 1:10:57 a.m. from owner to mom Jorge. Jorge, question mark, call me. If Jorge is with you, can you have him call me, please? Text to Mo. (1:18, 16 seconds on June 2nd. Owner to mom Jorge. I beat you to the punch. Want do the dartboard with me? Come. Owner to Mo. I know you won't answer, Mo. Tell him to come finish the dartboard with me, please. Owner to Mo. I miss him. Owner to mom Jorge. Ask Jorge to call me, please, when he gets a minute. June 2nd, 7:43:40 a.m. Can you have Jorge call me, please, when he gets a chance if he's with you? 7:45 a.m. Owner to Mo. Going on to page 16, June 2nd, 2019, 10:50 a.m., 55 seconds. Owner to Mo. Hello. Can you please have Jorge call me? Willing to give back. Don't know if he's there or at parents. Really want to see him. Owner to mom Jorge at 10:52, 16 a.m. Not pursuing after 12 o'clock. Ever again. (12:19 p.m., 23 seconds. Owner to mom Jorge. Please call. Come over. I'll come get you. Come over, please. I need a super hug. Hugs? Please, need. You. 6:23 p.m. Owner to Anna. He doesn't live here anymore. Call parents or Mo in response to an incoming phone call that was made at 6:10 p.m., 54 seconds from Anna to owner. Entries 9803, 9804 in the PDF timeline, June 2nd, 2019. Image 0092.heic, capture time 6:33:01 p.m. Image 0093 HEIC, captured 6:33:26 p.m. Publishing from attachments. Image _0092, metadata showing 6/2/2019, 6:33 p.m. And image or IMG _0093, metadata, date taken 6/2/2019, 6:33 p.m. (6:34 p.m., 51 seconds, June 2nd, 2019. Outgoing from owner to mom Jorge. All up to you now, big boy. And for the record, those images were sent to mom Jorge at 6:34 p.m., 33 seconds. Look what you made me do. Or maybe your mom will for you. Response from mom Jorge to owner. Wow, that's really childish. Owner to mom Jorge, but effective. Mom Jorge to owner, yeah, I see what you are doing. Did Lucas leave? Owner to mom Jorge, I'm watching shadows. Be gone for good, minus birth certificate. Mom Jorge to owner, okay, cool, enjoy. Owner to mom Jorge, am, nice, you're not. And nice was from mom Jorge to owner. Going on to page 17, this is still June 2nd, 2019. Mom Jorge to owner, yes, I am. You are not, though. Owner to Mom Jorge, to who? Your mom? Brothers? Not me. Mom Jorge to owner, to everyone. Owner to Mom Jorge, but me. Mom Jorge to owner, I love you. Owner to Mom Jorge, I'm going out at 8. Get dressed. I've given you since noon. Peace out, Boy Scout. Mom Jorge to owner, I'm coming over with a handle. I was helping Pop all day cut grass. Owner to Mom Jorge, yay you, getting in the shower then out, bye-bye. Mom Jorge to owner.
Excuse me, can we approach the bench?
Yes.
More continuing coverage in the suitcase murder. The Trial of Sarah Boone is on the way. From the Hidden Killers podcast and True Crime Today. Press subscribe now